What's up, everybody? We get so many questions about conspiracy theories on cases that we're following on this channel, about what ifs. And someone said, Pete Sardis and I have known each other for over 20 years, and we usually see eye to eye, but there are some things we see very differently. I'm going to follow the case. Pete's going to bring in the theories. What is mainstream media saying? What are the reports saying? Is it real? Is it fake? Did it come in at trial? And we're going to discuss it because, as we've seen in trials, one side or the other can do something that makes previously inadmissible evidence come in by opening the door. Make sure you subscribe on iTunes, SoundCloud, Spotify, wherever you listen to our podcast. Let me know what you think in the comments. What's up, everybody? Welcome back in to another episode of the Opening the Door podcast. And today we're going to talk about a case that has already concluded, a trial that has finished, from none other than Ed Sheeran, who won his trial recently. And I've got Pete coming on to explain what that case was about and what we're talking about on today's episode. So Pete, why don't you jump right in and tell us why Sheeran got it?
All right, so here's the basic gist. Ed Sheeran puts a song out by the name of Thinking Out Loud. This is a song that
Pretty big song,
yeah, hit back in 2014, all right? So right about the time, about 2018, a company by the name of Structured Asset Sales buys a third of the rights to Marvin Gaye's song, Let's Get It On, and then files a lawsuit against Ed Sheeran saying that the chord progressions in Think Out Loud are so similar to Marvin Gaye's song, Let's Get It On, that he has infringed on the copyright of Marvin Gaye's song. At this point, they want millions of dollars in royalties, parts of his sales for his records, and all that stuff that goes along with it.
So basically they're saying Ed Sheeran ripped off Let's Get It On from Marvin Gaye, and therefore he should pay his dues, give Marvin Gaye the money since he's the one, or the company that now owns the rights to the song, because they're the ones that made it what it is, and Ed Sheeran used that then to make money off of the back of work somebody else did. A lot of people know about copyright claims and things like that on YouTube. If they follow YouTubers, there's copyright strikes all the time. So this is basically that on a much bigger scale.
Right. And I don't think everybody really cared so much about this case, but for the fact that Ed Sheeran's involved. But it was kind of a big deal because from the music industry perspective, there's only so many notes in the world. There's only so many chord progressions. There's only so many ways you can put, notes together to make music. And what Ed Sheeran, and he actually was very vocal about it during the course of the 6 years that this lawsuit took to get to fruition. And the concept was, if I infringed on Marvin Gaye's copyright by writing my song, then I don't want to do music anymore because it's impossible to write a song in modern music that doesn't have some similarity to some other song. I'll kind of go into the details of what we're talking about. There's a group, they're called the Axis of Awesome. They did a bunch of stuff about 10 years ago. It's on YouTube. You can find it out there. And they basically take the 4-chord progression. That is the basis of most modern pop songs. And they play the 4 chords in series, right? And based on those chord progressions, they like sing like 25 different songs in the course of just playing those 4 chords. The point being is that's how similar popular music is, one song to another.
Yeah, and I mean, you can hear that when you listen to the background of a song. It sounds just like another one. There's all these remakes. And I think it's important to note that when there is a remake or somebody uses a part of a song, usually there's some kind of deal. They buy part of it. They pay them part of the royalties, whatever it may be. There's usually some sort of deal in the background. Obviously, that didn't happen in this case, but basically what he's saying is if Marvin Gaye sounds like this, then Ed Sheeran's song sounds like this. Oh, well, that's close enough, but there's a pause there, and they kind of get into the nitty-gritty. But at the end of the day, what is the legal question that's asked in a case like this? At the end of the day, when somebody says, you used my song to make your song, you made all the money off of this because of my song, what is the legal question that's actually asked in court?
The question that they ask them in court is, A, is this in fact an infringement on somebody else's work product? And if the answer is yes, what are the damages? And in a case like this, the damages are huge. The damages are parts of the record deals, the streaming, all of the the royalties that come up on that, and it can really add up to big numbers. And I want to throw in there because I want to make sure it's clear. Marvin Gaye had some issues with a song a few years back, "Blurred Lines." Everybody's heard of that one, and that's Pharrell Williams and Robert Thicke, and that was a clear ripoff. And the estate of Marvin Gaye, who actually litigated that case, got like $7 million in cash payments, and then 50% of the royalties that song would make over the course of time.
So they've done this before. So Marvin Gaye's estate has done this before.
And this is why this is important. Marvin Gaye's estate doesn't sue Ed Sheeran. A company buys a portion of this Marvin Gaye song in order to sue Ed Sheeran. So this was, in my opinion,
a piece of that action, basically.
That's right. They saw how big it was with Marvin Gaye's previous song, and I think they thought if we can buy a portion of the rights to this song, we can bring a claim. And they were hoping, I think, for a quick, fat settlement. That's what I think they were hoping for. It didn't work out their way in this particular set of circumstances because they lost, straight up lost.
So what's kind of the history of people doing this? What other songs has it happened? Because there are a lot of songs that sound the same, and I know that this has happened in the past. I can't remember one as high profile as the second artist making a song that kind of sounds like the first song winning, like Ed Sheeran did. I think this has a lot to do with likability of the client, like we talked about in other cases. And it seems like they just really liked Ed Sheeran. He testified in that case. It was he talked about it a lot, how difficult it was, everything else he was going through. And I think he probably ended up carrying the day because they listened to him and they liked him. But tell me about some other cases this has happened before.
Right. Yeah. And I'll just talk about the ones that I remember that were kind of big in my generation. Vanilla Ice versus David Bowie and Queen's collaboration, Under Pressure. So Vanilla Ice does Ice Ice Baby and literally took the hook of that song and used it. That's exactly right. So back in 1990s, they basically, David Bowie and Queen sue him. He winds up paying an undisclosed amount, but I promise you that undisclosed amount was pretty much all the revenue of that song, because what's Vanilla Ice doing today? He's building houses in Miami and trying to do whatever he possibly can to make a buck. So I think I think it pretty much consumed the profits. Another one, again, from my generation, my era of music, The Verve, Bittersweet Symphony versus the Rolling Stones hit The Last Time. Now, understand that in that case, the Rolling Stones had been approached by The Verve and they wanted to use the orchestrals, the basic, the string section. And the Rolling Stones said, okay, but there was a deal onto how much of the orchestration The Verve could use. And when they actually published the song live, there was a lawsuit because the management companies of the Rolling Stones sued The Verve and said, hold on, that's more orchestration than we agreed to. At which point, the result of that lawsuit was that all of the royalties went to the Rolling Stones and not The Verve. On a positive note, to give Mick Jagger some credit, back in 2019, he's like, this is just stupid. And he let The Verve have whatever portions of his royalties were going to be, because they made zero money on that album because of all the monies they had to pay in attorney's fees, royalties, and all that stuff.
And I think that's important. Like when you talk about litigation generally, and especially in the music industry, people are stealing stuff all the time. People are ripping stuff. People are sampling stuff. It's best to obviously go and ask, but once you go and ask, like a case like this, you're admitting that you're using part of the song. And then, the suit, as other people call them, they see an opportunity, they buy a part of the song, like in Marvin Gaye, and sue them. A management company for Rolling Stones sees an opportunity and sues them. So, there's all this stuff going on at all times, business managers and lawyers and everybody getting involved, looking for an opportunity to sue. And that's what it felt like a little bit with this Ed Sheeran situation.
Right. And you know what? You've got to give young artists, this is Pete's opinion, you've got to give them some latitude, because all artists are inspired by something. And if you look at some of the music, I mean, I don't want to name names because, I don't want to put anybody on the spot, but you can tell what kind of music they liked when they were younger because it shows through in their style of music. You know what I mean? Does that make sense what I'm saying? Like, you listen to Elvis, and if you were a fan of the blues before Elvis was Elvis, you can kind of see that inspiration comes through in his music. You can hear Madonna, you can hear some of the people that she was interested in as her music came through. You can listen to Lady Gaga, and you can tell me you don't think that she was a Madonna fan, but I'm going to tell you what, she's a Madonna fan because there's a lot of that same stylization of that music in the way that she performs. I'm not saying she's ripping anybody off, but she's inspired by that genre of music.
And I think that's tough. Like putting this type of stuff in front of a jury, it was in federal court, putting this type of stuff in front of a jury is really interesting because they've got to sift through it. Because Ed Sheeran's situation, he had to prove, and he called, who he made the song with, prove that this was independent. They sat down, they started thinking about a song they want to make. If you've ever seen, I've never been in the music industry, but I've seen movies about it. Most recently, A Star Is Born. And they're like, so she writes a song. He's like, this is kind of what I start thinking about it. Dun, 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 and they start going with a beat, and then you put the words to the beat, and it gets going. And they're artistically, what did you say? Influenced or whatever it is, inspired. Yeah. There's a guy, Forrest Frank, that's the singer of Surfaces. He posts on his Instagram all the time how he starts out with the keyboard and he does this, and then he does some drums, and then he sings over it, and he kind of shows how he puts the song together, which is pretty interesting. Could be documentation for future cases if anybody sues him. Yeah. But the point is, even though he does that, it could still sound like Under Pressure or We Will Stomp You or whatever it may be, because like you're saying, those beats can sound so similar. And because you like a certain kind of music and you memorize it or you listen to it so often, if I were to write a song, maybe it would sound like another song that I like or a type of genre that I grew up listening to. And how you parse that out in a trial is very, very interesting.
I think the hardest part, let me go back to something that was obvious, like Ice Ice Baby versus Under Pressure. I mean, that one was obvious. I think they showed up to the jury and said, just listen. They never got to a jury, but here's yours. Here's ours. Clearly, you ripped this off. But with Ed Sheeran's song, I mean, are there portions of the rhythms that are mnemonic?
I'll just tell you, I've heard Thinking Out Loud a million times. I've heard Let's Get It On a million times. Never did I ever hear any connection. The other one, like the Ice Ice Baby one, you can't not hear it. You know what I mean?
Clearly. And that's what I'm saying. With the Ed Sheeran song, is it possible that he was inspired, even if it's subliminally, by that song? Yeah, sure. There may be part of the melody or some part of like some of his harmonies that kind of are musically similar, but we're talking about two totally different songs here, right? I mean, one does not make you say, hey, that's Marvin Gaye. Oh, no, it's not Marvin Gaye. It's Ed Sheeran. Yeah, it just doesn't go there.
And Ed Sheeran was even quoted after the trial saying, we've spent the last 8 years talking about 2 songs with dramatically different lyrics, melodies, and 4 chords, which are also different and used by songwriters every day all over the world. These chords are common building blocks, which were used to create music long before Let's Get It On was written and will be used to make music long after we are all gone. And I guess that is a legitimate beef. It's like, so anybody can sue anybody and say you use these 4 chords. We have to draw the line somewhere. We talk about it all the time in our industry, baseless lawsuits, frivolous lawsuits. They can be incredibly frustrating for the person that's suing them. So we'll see if Ed Sheeran tries to get fees. Have you heard anything about that? Is he going to go try to get fees for them?
I haven't heard at this point if they're going to get fees, but I would be shocked if they didn't, because this was an expensive litigation. There's no doubt about it.
Just like how annoying. That is brutal. And I think somebody from Marvin Gaye's family also came out and said I was fighting for my father's, whatever my father left behind to try to make it a thing like that. But it's like, I don't know, maybe he would care. I don't know how these people care about this stuff, but there are some exceptions, right? Because we hear some exactly, spoofs or spinoffs of the exact song, and it sounds the same. The lyrics are different, but they sound the same. So why is that okay?
All right. There are carve-outs to copyright, and the big carve-outs, at least for our purposes in today's discussion, are parody, criticism, and comment. And the law basically says if you're criticizing or you're commenting about somebody's work, you can use it. Parody, it kind of falls into that. You're either making fun of somebody or you're using their work as a basis to criticize. And those exceptions are, I'll give it straight up, Weird Al Yankovic. Somebody comes up with a great song, Weird Al changes the lyrics, makes it totally hysterical, puts it out there. He is subject to the copyright exemption for parody. So totally authorized. It is an absolute ripoff, and he's not trying to sell it as if it's not. He's not trying to sell his work as his own.
Right.
Other than that, who else had a big one? Drake. There is an artist by the name of Jimmy Smith, and there was a song called Jimmy Smith's Rap. And it basically, in that rap, Jimmy Smith says jazz is the only real music. Everything else is just irrelevant. And Drake uses that exact. I mean, it's basically a sample of that song. His point being, though, is all genres have have relevance. All music is valuable, not just that specific genre, not just jazz. And again, Drake got sued by Jimmy Smith's estate back in 2014, and they kind of went through it. And the decision was just like in Ed Sheeran. Drake had the right to use that portion of Jimmy Smith's song in order to, again, criticize that particular work.
I also think it's interesting in the Ed Sheeran case specifically that certain things are copyrightable and other things are not. And those 4 chords, like, this has been litigated. And what you're talking about, what we're talking about, it's already been litigated, and you can't protect that. You can't protect the 4 chords, but the selection and arrangement of those chords is protectable. And in order to do this, I mean, it's just so interesting. Anytime we talk about a case, and I've never litigated a copyright claim or copyright infringement or anything like that. So it's just so interesting, though, that you apply the same legal principles and you prove the case the same way. So how do you prove whether or not these 4 chords were arranged and selected in a specific way and he copied those? Well, they called experts who listened to the songs and explained which chords were major and were primary and which chords were secondary or minor or not used as much. And Ed Sheeran responded to the plaintiff's experts by saying, I know what I'm playing. I know how I'm playing it. I know the reason I'm playing it this way because I wrote the song this way. I played it this way. I wanted it to sound that way. And it is not the same as Marvin Gaye. And that at the end of the day prevailed because the plaintiff did have experts. Marvin Gaye's conglomerate had experts saying that those chords were selected and arranged in the same exact way or enough of the same way as Let's Get It On to infringe on their copyright. And the court found before the trial even started that they had enough to go forward before a jury. And there was enough to be copyrightable and infringed upon based on the selection and arrangement of those chords, which is really interesting to me, legally speaking.
I like music. And I thought about, as I'm doing the research for this particular episode, and it's like 1, 2, like chord progressions, 1, 2, 5, 4. That is that chord. Let's just use those numbers as a chord progression. That is a formula that the record companies have figured out sells music. People like the musicality of that type of arrangement. So every song in modern, not every, the vast majority of music in today's, popular culture has those chord progressions. Now, it may be a different key, it may be, a different rhythm, it may be whatever the differences are, but it's still, like you said, it's the 4 same chords. It's just a matter of, do the words sound similar? Is the musical arrangement, is the score similar? And the question is, how similar is too similar? And it's kind of, that's up in the air. That's gray area because there's no test. It's not like if you have this and you have this and you have this, that's an infringement. It's, I know it when I hear it, or I know it when I see it.
And one of the big things about that is, just like in our cases, if we're saying, we're proving an injury happened and we're showing 2 MRIs, the jury wants to see the actual photos and the slides of the MRI. They want to compare it themselves. They want to see if they can see an injury. Well, in this case, they literally heard the 2 songs over and over again. They were able to compare them. When the jurors were interviewed after the trial, they said that made a huge difference for us. Some of the jurors were in their 20s and 30s, which to me that's probably in favor of Ed Sheeran. And he actually played the song on the stand. Did you know that? He literally, during his testimony, played the song on the stand, and the jurors afterwards were like, that was so cool. Ed Sheeran played for us and explained it to us on how it worked. We think that was a great move by him because he was able to show us what he was thinking and how he's playing it, and literally proving that he was the one that created this song in this way. The selection and the arrangement of the chords and the lyrics and the melodies. I mean, come on. That's a home run. And that's the point about the client winning the case. The jury has to determine which client they believe, which client they like. And that's how it comes down a lot of times.
Right. And, you've got these two competing experts, and you're talking about people that are obviously experts in music theory, right? So they come out there, and I'm sure it's just like when we have experts that get up there and start, well, here's this disc, and here is this herniation, and you see this little blob here, this means that. And I think there comes a point where all the jury hears is wah, 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 wah. They heard the song, and they heard Ed Sheeran's theory on how he got to it. They can't hear Marvin Gaye's perspective because Marvin's gone. But at the end of the day, I think the songs are not similar enough that it was like, oh, come on, but you clearly stole this song.
Right. And I
But
think
I'll
that's
tell
the
you,
point.
yeah, but I don't think this issue's over yet.
Go ahead. What were you saying?
I'm sorry. I don't think, though, the issue is over yet. I still think that there is enough money to be made that we're going to still see copyright infringement cases.
And I think that's because there are so many similarities through a lot of this stuff and so many similarities to the chords, like we've already talked about. But to me, I don't think a lot of musicians are going to want to do what Ed Sheeran did in this case for 8 years, fight it, pay lawyers, get on the stand, testify, play the song, explain what they did. Or could we see the reverse, like I talked about with Forrest Frank? Like, are they going to start documenting how they write and how they create this song to prove that at the time they did it this way, they weren't stealing anything? Because you can lay songs over each other and put words to different songs or swear, oh, that sounds just like that song. But then when you hear it, it is just a little bit different, especially for somebody that does not have a trained ear like myself.
Right.
So I do think it is kind of frustrating to say that, it goes both ways, right? It'd be frustrating. Yeah. I know if I created something great and somebody else stole it and just changed it a little bit and got paid for it, that would be frustrating as well.
I think that Ed Sheeran, when this happened, maybe he was just in a place in his life where he's like, you know what? No, I'm not just going to pay you because you bought a third of the rights of some song so you could sue me. I'm not going to just give in because that just, progresses the problem. I'm going to fight you because in my heart of hearts, I know how I got to this song. And I'm going to make you go all the way. Because what happens if I lose? I lose the rights to my song. Big deal. Ed Sheeran's got more than one song.
Right. Right. I mean, he doesn't want to lose that, but sure.
Of course. But, for some smaller acts, one of the things that I found out was that the vast majority of people will actually go to artists that they think their song may sound similar and they just buy in so they don't have the issue. And it's more prevalent that all of that happens, which is really great for those, vintage or those senior artists because they're just getting paid a penny or 5 cents or whatever it is every time that song plays. But it keeps the litigation down to a minimum.
But I agree. So talk about when you sue for this, we talked a little bit about what you kind of go after, a cash payment, royalties, things like that. Is that ongoing? How does it work? Like it's not, because in the other case, there was a cash payment of $7 million, but then there was also royalties and things like that. Can they just collect forever, or what are the damages? How do you calculate them, especially if they're ongoing, like it would have been for Ed Sheeran?
The answer is yes. If the judge or if the jury gives you royalties in perpetuity, that means every time that song plays, you will get a piece of the action for that song. Now, understand, like in older music, the older a song gets, the less and less play it gets. That's just natural, right? So it's a great way for a vintage artist or somebody that, it's not as popular anymore to get back on the bandwagon by getting a royalty from somebody that's got a new song because it gets a piece of the action of every time that song gets played forever and ever. There's also album sales. People still do sell, records. There are still vinyl records. I don't know if there are CDs anymore, but when you download something from Spotify or whatever the case may be, you actually buy the album. A portion of that can be used as recovery, as damages. Whatever monies you may have made, for example, as a portion of your world tour, they can get a portion of that. Because if you went on tour and sang that song live, every time that song gets played, every time it hits the radio, every time you sing it in public, that is a performance, and it's the performance that dictates what the payment will be.
Yeah, and I mean, I think that's where a lot of the money comes from, especially the easy money, and that just like keeps compounding over time.
And it's got to be big. You can't sue some little artist that kind of sampled something that's
not worth it.
50,000 records. It's not worth the 2 cents per 50,000. It's not going to worth the legal fees. But, on an Ed Sheeran type of, performer with huge, huge multi-million album sales. And, in today's world, multiple hundreds of millions of streams, it could be very lucrative very quickly.
And the last thing I want to talk about to finish with is just like in every area of law. That's why it's kind of fun to talk about a case I have no clue really what it's about, because it's still civil litigation and following trends. And I think one of the reasons this one happened, again, was off the back of Marvin Gaye winning a different case and some other artists winning some copyright infringement cases. This one was big, and I do think that there was more to it than just Ed Sheeran's case. One of the reasons he did it, which is the same reason we do a lot of things in our cases, which is we talk about principle, or you talk about, it's not just about the money, but it's about making change. And I talk to clients sometimes about making the road safer, making the trucking industry safer. Like, if this guy can't handle a truck, we need to get him off the road. If this company won't train their drivers, then we need to make them pay and make them realize it's worth it to pay your drivers, to train your drivers than it is to settle lawsuits like this or pay lawsuits like this. So I do think there was an element of that for Ed Sheeran. So talk about how you think it's going to affect the music industry now as far as the litigation goes with copyright infringement, that he won a case that may have some similar sound to the plaintiff's song that they sued for.
I think that this recent development of corporations or companies buying portions of the rights to a song simply to use them as a sounding board or whatever to bounce into
just a way to sue somebody, right?
Just a way to get into it. I think this is going to be a little bit, they're going to think about it twice, because they lost money on this case. No matter how you look at it, they had to pay for a third of the rights to the song just to be able to sue. Then they had to pay for 8 years of litigation and attorney's fees and all of that. And at the end of the day, what they get? They got zipped. So I think a lot of this concept is going to be second guessed. So we're not going to see it as much. But I still think, go ahead.
I was just going to say, I think what it's going to do, which is what we want in every industry, think twice, make sure you have a real case, make sure you have a good case before you file a lawsuit and sue somebody, because it affects people's lives. And I think that's good. I think this is going to have a positive effect to only sue if somebody actually rips your song, not if is close to, it's like, give me a break. Right. It's a totally different song. A songwriter wrote it. It's not like, Milli Vanilli style. Milli Vanilli, is that what they were called?
Yeah, Milli Vanilli.
Well, they were just lip syncing your songs.
Yeah, right. So we'll see. We'll see how it goes as time goes on. But there's so much money in this industry that there's always going to be the lure of that easy money. So I think you're going to still have a lot of deals that get made before litigation starts, saying, hey, my song might sound a little bit like yours. Let me give you 2% of every song sale, just so we're all, and
it could just be free money for the person that wrote the original song, right?
That's right. You're not getting any airplay, and all of a sudden you are. Money now is there's a lure to that too.
Exactly.
Hey, it's still business, no matter how you look at it.
Exactly. All right. Well, that's all we got. We talked a little bit about what came in at trial, what we think is next. Thanks for joining me, Pete. Until next time. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast, featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.